Could we have the next slide? All right, we'd like to thank our sponsors. TMA has numerous sponsors that make today's presentations and presentations like this possible. Please take a moment to note the names of the people, the firms you see on this slide, the ones you know and the ones you may not have yet had a chance to become familiar with. Please keep them in mind as opportunities arise, because these are the companies that are trying to help make you able to do your job better. Next slide, please. All right. We have a number of outings coming up in the near future. Coming up early next month, private credit, a different kind of lending. That's November 7th. Our annual holiday party will be on December 11th. And we have a couple of events coming up early in the following year. These can be signed up for or registered for at the website turnaround.org/Detroit. And with that, let's go into the next slide here. Let's kick off and talk about today's panel. Today's panel consists of Caroline Giordano and Ashley Higginson. Caroline is a senior counsel at Miller Canfield's Litigation and Dispute Resolution Practice Group. She is based out of the Ann Arbor office, and she is a member of Miller Canfield's Artificial Intelligence team. Also joining us today, we have Ashley Higginson. She's a principal in the Lansing office in the Labor and Employment Practice Group. She's also a member of the firm's Artificial Intelligence team, and she's co-chair of the firm's Higher Education team. Today, these two fine presenters will help us understand how artificial intelligence affects the workplace, which is an important topic as we seek to turn around struggling organizations. And with that, I give you Ashley and Caroline. Take it away.
Hello, everyone. As Ron said, I'm Caroline Giordano, and thank you for joining us today. I'm here with my colleague Ashley Higginson. As Ron said, we're part of the firm's artificial intelligence team. So we've spent the last year or so studying what AI is, what its pros and cons are, what legal problems it has caused, and how best to sort of game plan around those problems. So likely some of you have already used some form of generative AI in the workplace. Typically, I ask for a show of hands if we're doing this in person, but I'm going to imagine that some of you have used it in the workplace and others of you have maybe used it personally or outside the workplace. But you likely know that the current state of AI is constantly developing, and there's a lot of information out there. It's often difficult to find general, straightforward answers to our questions about AI and how it sort of interacts with and affects the workplace. So that's why we're here today, to provide you with some helpful general synthesized guidance on AI in the workplace. So before I get started, I just want to give you a roadmap of our discussion today. First, we're going to give you a refresher on generative AI, its risks and benefits, and some helpful uses for GAI in various settings. Second, we're going to discuss enacted and emerging legislation on AI and how the federal government has sort of addressed AI so far. Next, we're going to think about employment policy considerations and the risks that AI poses to some confidential information that may be found in the workplace. And then we're going to wrap up with some thoughts about AI policymaking in the workplace. So to get started with the basics, when people say generative AI or AI, what are they talking about? Generative AI is defined as a set of rules or an algorithm that can be used to create different new content like audio, images, text, videos, or even PowerPoints. It could also be described as machine learning. So essentially training computer programs to create new things on their own. Maybe the most common GAI tool going right now is ChatGPT, which is a chatbot that is trained on huge amounts of human language-based content. And ChatGPT creates responses to your queries in a way that mimics human language. So I'm imagining that many of you have used ChatGPT, or you may have used Microsoft Copilot, which actually runs on ChatGPT. So when I first started learning about all of this, one of my main questions was, well, how does this differ from a regular Google search? So the key difference between doing a Google search and using ChatGPT is that a Google search will only search existing information on the internet and tell you what it says, because it generally just searches and classifies results. Generative AI, like ChatGPT, creates an entirely new result for you based on you're querying based on the information in this system. So many of you, some of you may have ordered, for instance, groceries online. If you've done that, probably in the last 12 to 16 months, you've received notice of an updated terms of service, allowing these services to take all of your ordering history, prices paid, preferences to improve services to you, quote unquote, improve services. That means that every single order, keystroke, note, and payment that you've made to this online grocery system, if you've used one, is probably being fed into a GAI tool to predict what you're going to order, what you'll order, and to find ways to make you buy even more. Again, if there, GAI is everywhere. So if you've published tweets or Facebook posts, ChatGPT, or Google's Gemini, which is another GAI tool, has collected your tweets and posts and provided them their GAI's tools, provided these things to their GAI tools to make it part of the broad data set, to teach the tool and train it, keep training it to behave in a way that can't really be distinguished from the way a human behaves. So if we move on now, a lot of the presentation today, admittedly, because we're lawyers and we're interested in risk management, we'll be warning you about various concerns, that are raised by GEI and especially with respect to the workplace. So before we do that, I wanted to just pause before we launch into that with the understanding that AI obviously has many incredibly helpful uses across all kinds of different fields. So these are just a few that are listed here. There's a potential for huge workplace efficiency gains with GAI. GAI can organize and construct all kinds of content that you can use to draft things from scratch that make it easier to draft than from scratch, like letters, PowerPoints, emails, charts, and graphs. In the healthcare field, medicine field, GAI can help provide personalized treatment plans, which can help speed up diagnosis, improve outcomes. It has the potential to revolutionize biotechnology, which makes healthcare more accessible or can make it more accessible and cost effective. In the fields of robotics and automation, GAI-powered robots, which are, they're right around the corner, if not already here, they can perform complex tasks in manufacturing, logistics, and other industries. And these machines can adapt to changing environments and learn from experience. In terms of science, GAI, as we have said, it can analyze huge amounts of data, see patterns in the data, and actually make new discoveries, which can help researchers in fields like physics, chemistry, astronomy, any scientific field, really. And then finally, in terms of education, because it's so adaptive, GAI can provide personalized tutoring that's tailored to individual learning styles and enhance educational experiences for students. So that can be a tool for students and educators across various subject matter. As far as the employment setting, which is a lot of what we're talking about today, there are some useful tools that GAI offers at the moment. For recruitment, HR recruitment, AI tools can allow an employer to sort of decide the most important qualities they want to see in a successful applicant for a particular job. So, for example, if you're an HR director or you're advising one, a company might want to see someone with experience for a specific number of fields in a specific industry with specific tasks listed. The tool then will review every single application and CV and screen out all of those that don't fit. So there's a tool, for example, called My Interview that actually engages in one-on-one interviews with candidates, mimicking a human interviewer and analyzing and classifying the candidate based on their responses. But one issue, and this is going to come up again with GAI, is that these are not always accurate. So there's one instance we know of where this My Interview tool classified a candidate as a fluent English speaker when they only spoke German and had answered all of the questions on this interview in German. So these AI tools that handle the HR questions are interesting. We think that they're competent to handle very basic questions. For instance, how do I check my remaining PTO? How do I book PTO? How do I refer a candidate? Those kinds of basic questions. but we wouldn't want these tools dealing with complex questions, something like a sex harassment incident, discrimination, or a request for accommodation. Those are currently too complex to want to have a GAI tool advising you on them. And for a lot of these tools, it feels at this point like the people who are selling them are sort of relying on the promise of GAI in the future rather than the current capability of these tools for HR. Another example, we know of a large company that purchased a GAI tool set for a 9-figure sum, only to find out that it didn't really work like it should. And it realized it didn't pull from the correct content, and that as a result, it's routinely giving the wrong answers to even basic questions. So the bottom line there was that that company is now using its employees to spend time teaching this GAI tool that they bought on how to answer employee HR type questions. So there's a right time to jump into AI and a wrong time to do so, and deciding to do so sooner and in what way may not always be the right decision. The technology is brand new and it has tons of promise, as I said, but it may not pay always to be an early adapter. So I think if we could, are we able to go on to the next slide, Ashley?
Yeah, I didn't know there was a poll going. So
Oh, okay. So we got a poll here. Do you currently use AI? Okay, it looks like yes, 67 no to 33. That's about consistent with what we've seen when we've asked others. It's definitely a majority that are using it. And that number is going to go up. It's going to go up for everyone.
yeah, and an important component of that is, I think, when we ask that question, the second question is typically how many of you as employers have a policy around AI or the use of AI in the workplace? And ultimately, that answer is typically very few,
Yes.
which is why we're here today in part, and kind of an awareness of at least getting in front of a potential area of exposure. Fun.
Great. All right. So for all its promise, as we said, there are still general dangers that GAI poses, especially if you're not aware of them. One of the biggest problems is that GAI really likes to agree with you. Remember that GAI is intended to teach the computer to mimic being a human and to react how a human would. Most of us try to be agreeable, right? And GAI actually tries to do that as well. Any AI system is trained and built on the back of this massive data set. For something like ChatGPT, it uses a data set that's about the third of the size of the Library of Congress. But for tools that are available in the workplace and that HR departments might like to use, like those we were talking about earlier, that data set is probably going to be a lot smaller. And you can probably imagine what the GAI does when it lacks the data it needs to complete the task that you asked it for. The answer is that it makes it up. It can make it up depending on what it thinks the answer should be. So that's just one sort of example of something to look out for. I'll talk just a little tiny bit later about risks to copyright and intellectual property issues with GAI. But bottom line is that GAI it can hallucinate when it doesn't have the right answer to your question, and hallucinate is the word that sort of AI proponents like to use. But basically, what this means is that the GAI lies to you. It gives you an answer that's not correct. There's a sort of notable example of this hallucination phenomenon in the legal field. Last June, there were 2 New York lawyers who submitted a brief to the court that contained citations to a bunch of cases. When the court reviewed this brief, it found that 6 of the cases cited in the brief were completely made up. The lawyers finally disclosed that they had relied on ChatGPT to find those cases. These were totally fake cases. The lawyers were not aware that they were fake cases. But that had happened and the lawyers hadn't checked up on this. And so the court ended up sanctioning and fining the lawyers. And of course, that's not a great result for them or their client. So again, cautionary tale on GAI hallucinations. You may now be wondering, or you might be wondering, what does the federal government have to say about AI? What about the legislation on these issues? Well, the law, as you may or may not be surprised to learn, is moving a lot slower than the technology. But there are some examples that we have of federal action being taken. One of them is that in May 2023, Senator Gary Peters, who was chair of the Homeland Security and Governmental Affairs Committee, introduced bipartisan legislation to create an AI training program for federal supervisors and management officials. So this training program would help improve the federal workforce's understanding of AI applications, ensure that leaders who oversee the use of these tools understand AI's potential benefits and risks. So the federal government seems to be taking its time gathering information on GAI, but we do expect to see more proposals for legislation that not only regulate the use, but regulate training, which is really, really important, as hopefully you all recognize because you're here, training for officials, companies, and developers that are creating the GAI tools. In line with that, the federal government on October 30th, so about a year ago, President Biden issued an executive order along with a summary fact sheet concerning the safe, secure, and trustworthy use of AI. So the order mandates various federal agencies to develop new rules and regulations reflective of the administration's goals. And Ashley, if you could move to the next slide. So it's a very sort of ambitious executive order. It has a lot of goals, but it stresses, among other things, the need for new standards in AI safety and security, the importance of safeguarding the privacy of Americans. It declares an intention to address equity concerns within the use of AI. It sets forth goals concerning consumer, student, and patient privacy. It sets forth the goal of having the U.S. continue to lead the way in AI innovation, responsible government use of AI, and most important for our discussion today, it examines and finds very important the use of AI in the workplace. So as to the role of AI in employment, the executive order states an intention to develop principles and best practices to mitigate the harms and maximize the benefits of AI for workers by addressing job displacement, labor standards, workplace equity, health and safety, and data collection. That's a huge task to undertake, but those are the goals. It also states an objective to produce a report on AI's potential labor market impacts and to study and identify options for strengthening federal support for workers facing labor disruptions, including from AI. So this order, as we said, was a year ago. The law moved slowly, but we do expect several proposed rules and regulations for the federal government surrounding the use of AI engendered by this order, I would say soon, and in the coming year. So that's just a really brief overview of the federal scene. I'm going to turn this over to Ashley at this point, and she's going to speak to you a little bit more about GAI legislation and then EEOC guidance and policy specifically.
Great. Thank you, Carolyn, and good afternoon, everyone. So I'm going to dig in for a little while on a couple of slides related more specifically to the Automated Employment Decision-Making Tool, or the AEDT or ADT. What is this? This is a computer-based tool that uses machine learning, or GAI, to make an employment decision. This can be in hiring, in promotion, in potential, bonus decision-making and things like that. And this has really become a focus of legislation primary to other areas of AI, maybe for a few reasons. A, because EEOC provided guidance about it, which I'll talk about soon. But B, because it has a very real effect on employment decisions that can lead to both disparate and both disparate impact and disparate treatment results. So individuals of protected classes being discriminated against by machine learning. And so that is why it's kind of become a central focus of legislation at the early onset, protecting employees and applicants in the workspace. So just some of these examples are going to be listed here, but with the increasing adoption of AI in the workplace and in business in general, there's been a lot of pressure to regulate its use when it comes to hiring and promotional decisions to protect against potential abuses and discriminatory impact. So kind of a real world example of that. When we think about Title VII discrimination laws, we often think about a single plaintiff or an individual who's indicating disparate treatment on the basis of a protected category. Of course, there are also discrimination claims that allege disparate impact, which mean on their face, a policy or a process can seem extremely neutral. But when looking at the very real impacts of that policy or that AI tool, as focused here, the impact of that is in fact very discriminatory. And Amazon, as one example, attempted to create their own AEDT tool, and they kind of experimented and worked with it. They did not utilize it in reality ultimately. And that's important because in experimenting with their tool, they learned very quickly that the AI tool would garner information from CVs and resumes and immediately make outputs on their own decision making that certain applicants were not qualified for very obviously discriminatory reasons. Case in point, any individual who went to an all-women's college was near immediately rejected for engineering and computer-based jobs. Similarly, anyone with a interest or a affiliation with an all-women's group or other types of protected status groups were immediately spit out of this machine learning tool. The reason for that is not because inherently a machine is discriminatory, but because a machine utilizes a history of information, even the size of Congress, that history and information in and of itself might be discriminatory in the sense that in reality, women have not been in the role of engineering jobs as long as men. And so in that way, Amazon quickly identified this issue and closed this project. So with that comes the reality that legislation in this space has been very common. 40 bills have been introduced in states and territories for various task forces and committees and laws surrounding hiring and promotional decision making. The first of that kind was in New York City, as set forth here. Illinois also has one as it relates to AI videos and video interviews, governing the use of video interviewees or robot interviews with jobs, allowing individuals to opt out of that option and also delete the contents of those interviews. And in Maryland, the prohibition of facial recognition tools in the interview process. Many of these laws look the same. They're driven at the idea that employees or applicants have a right to opt out and have a right to remove the material that is utilized in making this decision after it's done, A, and B, requires some level of audit by the employer in utilizing this tool or system to make decisions. From here, other laws have been developed in cases or in states such as Colorado, who is requiring the use of reasonable care to avoid discrimination and mandated disclosures to any consumers or applicants that are using a system that uses AI. There has been some changing legislation surrounding the idea of criminal liability for certain use of AI systems and deep fake and other types of fraudulent activity with AI. So we can assume and see this type of legislation to continue in the employment area, but also for that to expand in other areas as well. One note, California's legislation in this area was recently vetoed by its governor. It may have been something you noticed. It garnered some national attention. That AI bill would have been one of the most far-reaching to date, and it was importantly set in the state that owns Silicon Valley, of course. So in that way, that legislation was seen as a blueprint for nationwide legislation around creating GAI systems. That legislation imposed liability on these tech companies that are creating these systems and models, and potential liability for the harms, discrimination, and other that they might create. It sought to create some type of kill switch that could end the AI system quickly, to the extent it ever did create, security or other sincere risks to, national security, state security, and employer security, and required certain audit and safety tests of the tech companies. The governor vetoed it, and it is no longer going to be pending legislation in California, but also perhaps provides a larger point on the tail or the friction that is the tech responsibility for these types of machine learning tools and our responsibility as an employer or end user in relying upon the tool. Historically, the internet has been provided kind of a laissez-faire safety in promoting technology and opportunity, and we as the employer or individual are left with the liability of utilizing it incorrectly. Thus, kind of the stress here and importance of creating at least some guardrails and a policy around your employees using it. So certainly kind of a good example of what really is a theme in this area right now. As we look to legislation in Michigan, so far there is none. I think it's safe to assume that we will see some soon, and it will track what we've seen in New York, Maryland, and Illinois, at least right now with our current legislature. And in that way, it would likely be very employee or applicant friendly and protecting those individuals from the GAI tools and its potential discriminatory impacts. So as I said, there is at least some guidance from the EEOC surrounding the use of these AEDT tools or GAI in the hiring process. It is a Q&I form document that's available online, and that provides some guidance to where the EEOC sees exposure or potential liability against employers or entities using AI systems for employment making decisions. Again, this focus is grounded in Title VII, Elliott Larson, similarly in our state, which would protect individuals from discrimination, including in hiring and employment. So, of course, the Q&A, I'll go through some of the questions and answers here without taking too much time. Essentially, the EEOC's guidance makes it very clear that using a GAI tool to make a selection decision or a hiring decision in whole or in part is using that tool as a selection procedure, which is a term under Title VII for which you can have liability if your selection procedures are, of course, discriminatory. Employees can assess whether a selection procedure has had an adverse impact, and critically must is what we're seeing with more and more legislation and more guidance from the EEOC. So by assessing, we're talking about auditing our tool in some way or another. An example or a recommendation that the EEOC is currently providing is to consider a selection rate. So a selection rate refers to the proportion of applicants who are hired, promoted, or otherwise selected when reviewing them on the basis of a certain protected category. The selection rate for a group of applicants is calculated by dividing that number of persons hired or promoted from the group by the total number of candidates in that group. Yeah, and so this idea of a selection procedure or rate being out of line with natural decision making. So if an individual, say, based on not that you'd necessarily capture religion in your application process, but if, say, the number of applicants who are female or of a certain religion apply at a similar rate to males and yet are disparately treated differently or by the selection tools decision making are automatically not considered more quickly, we need to audit that and decide why. It doesn't mean in and of itself it's discriminatory, but it is an indicator or a sign that it might be. So wholesale reliance upon these types of programs and tools can create a potential liability for the employer is the essential consideration or issue here that the EEOC is addressing. With that, the EEOC has also made very clear that the employer is going to be who's responsible under Title VII for the use of AI tools in a manner that becomes discriminatory or that becomes lacking in audit and review. So there, we'll maybe address in a moment, there are some cases that are considering where, if at all, liability should lie in the vendor or software creator. But ultimately, for now, we should make it is clear by the EEOC and courts at this point that the end employer is going to be liable for any decision making it makes, even if it's in whole reliance of a technology. The 4/5 rule has become sort of a rule of thumb, if you will, that the EEOC is providing to assist in determining whether there's a disparate impact potentially. So that idea is that the selection rate for a certain group, gender, race, religion, etc., protected under Title VII, is substantially different than the selection rate of another group. So that rule of thumb sort of indicates that a substantial difference than another is a ratio that's less than 4/5 or 80% differential. The EEOC, of course, will not hold strong to that and suggests it's just a rule of thumb and will be not necessarily appropriate under certain circumstances, such as if you're a much smaller or a much larger employer where those numbers would not be as logical to showing a true differential in selection rate. And ultimately, the bottom line of all of this in the legislation is very clear that we need, if we're going to be utilizing AI tools in hiring, promotion, or other types of decision-making for our employees and applicants, we need to be auditing that machine learning tool to determine whether or not it is creating an impact that is adverse. Some quick current litigation in this space: Mobley versus Workday. This lawsuit filed by Derek Mobley is a class action lawsuit against Workday, again, the software or technology, alleging that its AI-powered resume screening tool discriminated against him as on the basis of his race, disability status, and age. He indicated he applied to over 100 positions that use Workday's systems and had not received any of them. The case was dismissed initially because of the decision by the court that the software tool was not the decision maker. These 80 to 100 employees that did not hire him actually were, kind of what I was just discussing. But recently, the court agreed to allow for amendment to the complaint to include potentially Workday as an employment agency, a definition under Title VII, or a partner essentially to the employer in making that decision that could potentially subject them to liability too. So a little room there to potentially add in software vendors as individuals liable for these types of actions. But of course, the employer rather will still be on the hook in these spaces. An important note on that is, as we continue to utilize or ingrain AI systems into our workspaces, really important to be thinking about our contracting and subcontracting relationships. It might seem a little facetious at this exact moment to be adding provisions around AI, but you want to know who you're contracting with and whether or not they are utilizing security measures and systems in place when they use AI to assure that it is protecting confidential information, as Carolyn will discuss, or protecting from discrimination and other types of harassing behavior. Or you might want provisions that say we don't want you to use it at all because of concerns you have based on that contract. The second case is brought by the EEOC versus iTutor Group, and that case is an important reminder that in the world of disparate impact, and assuming we're not intending on discriminating against people, there are still moments where we can make decisions as a human that are in fact just inherent discrimination. So in iTutor Group, the entity or employer is an English language tutoring service to students in China, and it was alleged that it was violating the ADEA, Age Discrimination and Employment Act, by programming its software to automatically reject any applicant aged 60 or older. Obviously, the case settled. It didn't move forward on the merits because obviously that is intentionally discriminatory on the basis of age. So while an AI system is often getting the blame right now of being discriminatory in and of itself, we also as humans are placing the information into these systems at times in a way that can be discriminatory. So, being careful and cautious of our decision making when we're reviewing for bias as well. EEOC ADA refresher. The EEOC has also provided a very similar refresher or guidance tool as it relates to individuals, applicants, and employees with disabilities, and warns, of course, of the disadvantage that AI tools might create for individuals with disabilities in the workspace, i.e. someone who, may have a vision disability such that an interview with an AI bot will go badly merely because they're not able to look directly in the eyes of the AI bot, who assumes that means a lack of confidence. These are things that inherently might have nothing to do with the job and may not have been intentional, but in fact have a very real effect on an individual with a disability. So just an important moment in time to remind everyone, kind of as a general theme, just because there's a new technology doesn't mean we lose sight of the laws we're already aware of. That, holds true with the ADA. We need to be mindful as we use AI tools in hiring that we might need to provide a reasonable accommodation just for the application process. An individual with a disability might have a disability that's not at all affected by the job that they're applying for. They can do all the duties of that job with or without accommodation. However, they might need a reasonable accommodation to engage in our application or hiring process because it's utilizing an AI tool or technology of which they're not capable of performing equally to an individual without a disability in a way that is unfair. So just being mindful of that as we continue to utilize this new technology. Similarly, these systems are sneaky and can be sneaky in the way they obtain information. And we as hirers or employers hiring individuals do not want to know anything about an individual's disability status in advance of hiring. We merely want to know that they can perform the essential functions of the job, and our AI tools are not to ask disability-related inquiries or seek any type of medical examination. That being said, on the flip side, it's also important as we continue to grow in the world of GAI and its utility to think about how it can assist our individuals and employees with disabilities as well. The US Code makes very clear that the idea of auxiliary aids and services, which are things us as employers need to provide our employees with disabilities, is meant to be very broad and far-reaching. The code was not meant to be cemented in time, and just because we have a accommodation we believe is reasonable and works does not mean that we are able or allowed as an employer to deny an accommodation simply because it's a new technology of which we're not aware. And so in that way, if we are hesitant as an employer to utilize GAI systems in certain areas of our work right now, we do need to be managing and considering whether that tool can truly help an individual with disability to perform their essential functions upon request or upon consideration in an interactive process. So there's the space to be fearful and ensuring we're not discriminating, but there's also the space to be considering how this tool or new tools in this space can really be helpful for our employees as well. Speaking to the Biden executive order, there is a field assistance bulletin that has come out in 2024. We're expecting to see more proposed rulemaking as indicated. But this field bulletin, again, reiterates the idea that with new technology does not come closure on the laws we already know, the FMLA, the FLSA, the Polygraph Protection Act, etc. So essentially what this bulletin indicates is time spent working is paid regardless of productivity. In a world where we, imagine that AI can create efficiencies for us, we need to be considering what that means for our paid and hourly workforce. Does that mean that they work less, so we pay them less? Maybe. But in the meantime, despite our employees potentially using a system that allows them to work more quickly, they are to be paid regardless of that productivity when they are on the clock. Similarly, break time requires being completely off duty. You don't get to say someone is taking a break merely because the AI system is generating a quote or something for them and they're not doing it. They really need to be off duty. There also is potential concern in the FMLA and other disability or medical leave spaces that using AI systems can potentially create miscounting and other issues that require human oversight. Again, we don't want to be relying wholly on this type of technology when it comes to delicate items such as FMLA, disability leaves, and other types of leaves as we move forward with ESTA here in Michigan, which will be another leave we need to be calculating. So systems tracking leave can also potentially create concerns of retaliation if we have an AI tool that is sort of identifying someone it thinks is abusing leave. We want to be very cautious not to utilize that expectation or system identifier to retaliate against our employees. And then last, the bulletin has raised the concern that, again, GAI tools can sneakily learn quite a bit about an individual, and we have various laws in place, and certain localities have laws in place around things like banning the box and things related to not doing full background checks of potential applicants in advance of conditional hires. And so we want to make sure not to be identifying or finding those things using AI. We similarly do not want to be using AI as a deception review. So we're not allowed to essentially require someone to take a polygraph without them knowing, and AI systems are at least alleging that they can identify dishonesty, and we want to be extremely cautious not to be utilizing any system that is providing us an expectation of honesty or dishonesty in our employees or applicants. So again, a lot of high 30,000 feet above the sky guidance that we're receiving from the EEOC and Department of Labor, but it has important foundational ideas in the areas of law we've been working with all along since the beginning prior to the onset of GAI technologies. So from here, I will pass the mic back to Carolyn to discuss concerns around GAI and confidential information and copyright. Muted, Carolyn.
I was so sure I wasn't going to do that, and yet I did it. Okay. Ashley, if you could switch to the next slide. And thank you for passing the mic over. I'm going to talk, as you said, about AI and confidential information. Almost every workplace houses some kind of sensitive, confidential, or proprietary information. So think about your personnel files, financial data, proprietary, maybe you have trade secret information, investigatory material, etc. So your employees may have already started, you or your employees may have already started to use GAI to draft emails, conduct preliminary research, summarize documents, and to generate content and ideas. GAI, as we've said, is very good at helping with that. But while those kinds of tech-enabled tools can be useful, incredibly useful, they can also create risk, especially when you're dealing with confidential information. So what kind of risks am I talking about? Well, many GAI systems, including ChatGPT, are public-facing. What do I mean by that? Public-facing means any member of the public can use them without restrictions, but it also means that anything typed into that GAI system by a user will be utilized by the GAI to respond to future queries by members of the public and to further train that GAI system. So if you or your employees are using that type of GAI in the workplace, there's a potential for your confidential information to get out into the public. Once your confidential information is entered into a public GAI tool, it's, for instance, in relationship to a query that you're asking the tool, there's likely no unringing that bell and no telling where that information is going to go, who may be able to use it, how it's going to come out the other end for somebody else. Second, workplace use of GAI also raises some third-party compliance issues. Almost every workplace relies to some extent on third-party vendors. So this could be your data storage center, engineering subcontractors, your healthcare system, et cetera. All of those folks may themselves be using GAI tools. They probably are using GAI tools. And if you've provided a third-party vendor with confidential information to perform work for you, that vendor may knowingly or unknowingly be risking the information's disclosure, depending on the tools they employ and what agreements you have in place. Third, workplace use of GAI may also run afoul of various types of agreements covering third-party confidential information in your possession. So think, for example, if you received confidential information from a potential vendor or a potential partner that is subject to a non-disclosure agreement or NDA. We see this a lot when different companies are consulting with each other. They use an NDA because they're sending information back and forth that's confidential. Inputting that kind of confidential information or any part of it into a GAI tool risks violating the NDA because now that information is out there in the public. Last on the risks here, because we're attorneys, we also want to bring in the attorney-client privilege, which, as you probably know, protects as confidential communications between an attorney and their client for the purpose of giving legal advice. So inputting confidential information into a public GAI tool may have implications for attorney-client privilege too. If you or your employees draw on an otherwise attorney-client privilege communication with counsel, to formulate these questions for GAI, there may be an argument that you have waived the attorney-client privilege by disclosing that information to a third party, even though the third party is this chatbot. Again, because the law is evolving, we don't have clarity on those issues, but better to be aware of them on the front end than to try to have to put the genie back into the bottle. As I mentioned before, and as we've kind of suggested, the law specifically addressing GAI is moving much slower than the technology. But in the meantime, and Ashley echoed this in terms of the laws in the employment space, there are still any number of laws on the books that already prohibit the disclosure of confidential information. So, for example, I just chose these sort of at random, but there's the Identity Theft Protection Act, which prohibits using or attempting to use personal identity information of another person to obtain goods, services, etc. It remains to be seen how the use of personal identifying information in connection with AI might implicate that law, but it probably will. Another big one, we're all probably at least sort of familiar with the restrictions on disclosure of protected patient health information in the federal HIPAA laws. Again, there's nothing about GAI that changes the general HIPAA laws, and it's safe to assume that you can be held liable under HIPAA for disclosure of HIPAA protected information through a GAI tool, just like through anything else. Another one that we've looked at a lot is Michigan's FOIA, which is the Freedom of Information Act, which is a law that you may or may not be familiar with, but that affects a lot of governments. So if you're dealing with a government business partner, it might be interesting to you. Under FOIA, there are specific exemptions from the government's otherwise mandatory disclosure of public records. So, for instance, there are certain types of trade secrets that are exempt, attorney-client, of course, commercial financial information, law enforcement records, et cetera. Obviously, those exemptions are really important for the public bodies that don't want to disclose that kind of information. And we, as attorneys, we've sort of litigated these kind of issues, and we can tell you it's very important to have those exemptions in practice for the governmental entity. But it remains to be seen how, if at all, the governmental entity's use of AI might put a wrench in all that. Because if, for instance, it could be shown that a public body has already disclosed otherwise exempt material to a third party through the use of GAI, there could be an argument that those exemptions have been waived. It's also possible that AI use becomes as it becomes more widespread, the governmental bodies will start getting FOIA requests asking them, what GAI tools do you use? How have you used it? What queries have you used? So given the presumption in favor of broad disclosure under FOIA, we're advising governmental entities to be really intentional about how they use GAI in the public space. So all of this is overwhelming. It feels very overwhelming. It's a lot. What can you do practically to hedge against the risks to disclosure of confidential information through AI? Well, every situation is obviously different and unique, but there are some general best practices we can suggest. First, and you heard this a little bit before, and you're going to hear it again, you really need to think about developing, implementing, and regularly updating organizational policies regarding the workplace use of GAI. Policies are going to be key. And because the law is so uncertain, they're likely going to need to change as the law on AI comes into clearer focus and changes as the law always does, especially the law regarding technology. Once you have a policy, you'll need to make sure that if you're an employer, that your employees understand the policy. You may want to train your employees about the risks of GAI uses and how it poses those risks for confidential information. Or you may want to implement and develop a policy in which your employees are straight up not permitted to use GAI at all, or are only permitted to use it in specific circumstances. In any case, no matter what policy you adopt, it really needs to be updated and monitored and reassessed in order for it to be effective. Next, if you've determined that you want to use AI in the workplace, which many do, consider opting for a closed AI system rather than an open AI system like ChatGPT that you just get online. A private closed system would differ from an open system because it could be trained solely on your corporation's or the business's own data, and it doesn't feed into other queries back into the public domain. So the confidentiality risks with something like that would be reduced. The downside of that kind of thing, of course, is that it costs more, and it likely lacks the flexibility and the breadth of information you're going to get from an OpenAI or a ChatGPT type system. Third, you want to make sure you do your due diligence with respect to your third-party vendors' use of GAI, and you want to understand how, if at all, your vendors are using your confidential information in tandem with their GAI tools. You want to make sure you develop clear agreements with your vendors to put restrictions on that use where you need it. And finally, if you feel like you or your employees or someone you're advising are particularly concerned about employee disclosure of confidential information via AI, consider just executing an NDA or a related contractual provision addressing employee use of AI head on. So next, I want to touch just briefly on the intersection between AI and intellectual property, because it sort of dovetails with what I was discussing before. So AI has implications for all kinds of intellectual property, but probably chief among them is copyright law. So what is copyright law? Broadly speaking, copyright is a federal constitutional right that gives authors or owners of copyrights a bundle of exclusive rights related to those works for a limited time. So copyright protects all manner of artistic works, many of which are listed on the slide here. As business folks, or primarily business folks, I assume you might be thinking, well, what is all this about artistic works, and what does that have to do with me or with AI? Well, under copyright, artistic works, that phrase is extremely broad. And in particular, the concept of literary works covered under the Copyright Act is very, very broad. It's not just novels and poems. It includes many works that might not seem quote unquote artistic. For example, posts on your website, articles, essays, etc., marketing materials. It also covers photos that you create and post publicly, or computer programs you may create or use. So copyright gives the owner, as I said, a number of different exclusive rights, which are listed here. Reproduction and copying, modifying, adapting, distributing, performing, and displaying of the work, right? This is your bundle of exclusive copyright rights. And then, right. So if anyone violates any of the exclusive rights granted to copyright owners, the owner can bring an action for copyright infringement, provided that they've registered the copyright. So that infringement might look like downloading, uploading, sharing, or posting parts of a copyrighted work online without the owner's permission. So why is that all important in the AI context, and why is it important for you? Well, it's important because if you're an employer, or if you are advising an employer, counseling employers, you want to have a handle on what your employees are generating or creating using AI tools in their role as employees. That's because the Copyright Act allows claims for vicarious liability. If a copyright holder can show that one party, like an employer, directly benefits from the infringing activity of an employee, and the employer had the right and the ability to control the infringing activity but didn't do it. And a problem, as we discussed earlier, is that popular forms of GAI, including ChatGPT, they scour the internet to find content to address your questions. So in all likelihood, that content is going to include the copyright protected content of others. And you and your employees do not necessarily have the right to reproduce that without permission. Throwing another wrench in all of that is that ChatGPT does not typically reveal all of its sources. So if your institution or your employee is using ChatGPT to create content and then passing off that AI generated material as your own, even with disclaimers that it's AI generated, you could be exposed to copyright infringement risk. So again, all of this is to just illustrate why a policy is really, really necessary. And it's important to take potential copyright violations into consideration if you're dealing with third-party contractors as well. especially if the end product is potentially copyrightable work that you want to use, sell for your own benefit. For instance, some kind of marketing material or material you might put up on a website, etc. As with AI-related legal issues, as we've discussed, there's a lot of open questions when it comes to copyright and intellectual property. One big one is it's still unclear whether AI platforms have any IP rights in their own works. So far, the US Copyright Office has refused to grant copyright protection to any works generated by AI because they say the works are not generated by humans and therefore not registrable as copyright. So if you want to register a work that you used AI to create or used to create part of it, you essentially have to disclaim any part of the work that used AI on your copyright registration. You can only register the parts that were created by a human. So that's the Copyright Office, and the Copyright Office doesn't make the copyright laws. So this will play out eventually in the courts, which, as we all know, are very, very slow, but this is all sort of ongoing right now. There are a lot of recent cases you may have heard about that touch this area. One of them is a case called Thaler versus Perlmutter. This is, in that case, there was a plaintiff whose name was Dr. Thaler, or maybe pronounced Thaler. He tried to copyright a piece of artwork that was generated by his own AI model that he called the creativity machine. And the court rejected that and said it upheld the copyright's rejection of it, and the idea that it wasn't authored by a human, which is a bedrock requirement of copyright. Still, what that case left open is the sort of more important and complex question of the degree of human involvement that's required to copyright an AI generated or partially AI generated work for copyright. So it's likely going to be the case at some point, I think, that a court will find some copyrightability in works made by humans that use AI, but we're not there and we don't know what it's going to be yet. Another really high profile set of cases on AI and copyright have been brought by against OpenAI, which is the maker of ChatGPT, and in some cases also against Microsoft, which uses ChatGPT for the Copilot AI tool. The plaintiffs in those cases include really famous authors like John Grisham, Jodi Picoult, the comedian Sarah Silverman is one, and then the New York Times also filed its own lawsuit, all sort of arguing that OpenAI's use of their works to train these chatbots is copyright infringement. So they're saying you're using our work to train your system essentially without our permission. You can't do that. We have copyright in this. You need to stop or you need to get a license from us and pay us for it. So OpenAI and Microsoft, on the other hand, are arguing that this is not infringement and it's fair use. Fair use is a legal doctrine that lets you sort of use an author's work without permission in some situations. In these cases, OpenAI and Microsoft are likely going to argue that their use falls under fair use because it's for scholarship or research purposes and because it's transformative of the original content, has a different purpose than the original that advances the public interest. So that's all still ongoing while the jury's still out on that. The bottom line takeaway for you now is that while employees who may use AI-generated content might be able to claim fair use, until the court sorts this out, employers should be really wary of using AI for material that you want to protect through copyright or other intellectual property law. That's because if you use AI, there's a chance you're using another creator's content without their knowledge or consent, even if you don't mean to. If you are using AI to create arguably copyrighted material, there should very least be disclaimers that this material was used partially with AI, was not authored by the original content creator, that kind of thing. That's not a fail-safe, but it could be helpful. So now I'm going to hand this over to Ashley again, who's going to close this out by discussing some more practical policy suggestions for you to consider.
Great, and I'll be as brief as possible. I won't take more than 5 minutes or so and want to save some time for questions if we have any. You'll have these slides, so they'll be helpful in their own right if needed. Essentially, what we're here today ultimately to provide you after some doom and gloom is just some practical guidance of policy provisions you might want to consider in advance of this ever-changing landscape. And so ultimately, what we think this looks like and what we recommend is something that is either folded in to an already existing policy or a policy you create that's essentially an unauthorized software prohibited type policy. I'm sure most employers already have this. There are any number of websites we don't want our employees engaging on while they're in the workplace. And this may be just another example of the type of work we don't want them to be conducting at work. And so our kind of inherent policy is at first, unauthorized software prohibited. These are each a slide, so I'll move on. The first component will be that use is prohibited, and unauthorized use of chat GPT or other GAI systems is prohibited unless and until we approve it as the employer. This allows you to potentially engage in discipline to the extent necessary when an employee did not obtain approval. And so after the unauthorized use prohibition, the no, we have a but. The but is the approval process, and we'd recommend that an employee be designated to use AI if needed in their workspace and what reasons that they're utilizing it be provided. A department head in conjunction with legal or a head of IT should consistently recommend and approve this, determine what kind of software you as the employer are comfortable using, how long you'll be using it for, and things like that. And the approval process should be a fairly routine and general form that says what you want to use, why you want to use it, who will be using it in your department, etc., and for how long, ensuring knowledge about the privacy policies of whatever system that is, ensuring maybe training if that's required, and items like that. So a form that's approved by a department head and reviewed by a consistent individual like IT or the general counsel in determining where and when you want your entity to be using AI in the workplace. You'd also want these employees or individuals who are using it to agree to certain conditions where it is appropriate. So the employee needs to agree to adhere to conditions of approval and agree to any acceptable uses or unacceptable uses of the AI in the workplace. So agreeing to acceptable uses may be things like this: brainstorming ideas, Excel spreadsheets, using it for coding, general knowledge questions, nothing that is a final or formal document, nothing that is a receivable potentially, and items like that, or use for general knowledge or for assistance in creating a receivable that is always ultimately approved and reviewed by a human. Other acceptable uses may be an AI system we're using for hiring, subject to a condition of audit or review for bias. Any number of items depending on the business that we're seeking to utilize the system for. Unacceptable uses at a minimum might be items such as these: infringing on the rights of others, including privacy and IP rights, interference with the performance of job duties, using any text created as a final work product without fact checking or without a disclaimer, potentially. Inputting any confidential information, of course, a huge no-no if we're using an open AI system, and a failure potentially to properly cite the use or incorporation of an output into your work. And then I flag here always as kind of a hot button issue is the idea of note takers. So we all approved a AI disclaimer before we even entered this presentation. And while I think it can be really helpful in the right environment and context, more and more, we're getting employees who are very uncomfortable with note takers that are in a Zoom meeting for any number of reasons, maybe because the intention of the meeting is to be more candid. Whether or not it's a good thing they're worried, I don't know. Whether or not it's because it's really a confidential meeting that we don't want either a public foiable document of, if we're a public entity, we don't want a AI system obtaining our confidential information if we don't really know where that information goes other than the note taker. We don't necessarily want a note taker taking attorney-client privileged information down. And so in this way, flagging that as a place in your policy, you might be wanting to think about its utility and whether or not it's helpful or not. I also see note takers being used in place of humans. And on the one hand, perhaps if a administrator or executive is unable to make a meeting and wants the notes, we're comfortable with that. On the other hand, perhaps the idea of participation is critical to the whole vision. And so we don't want our note takers in place of actual human engagement. So just a flag on one unacceptable use I'm seeing more and more lately in the employment space. And then enforcement. Now that we have a policy, it really can be a skeleton of one where we're just navigating and at least have some understanding of when and why our employees are using GAI tools. We can enforce that policy, right? So like any other policy or HR policy we have, if someone is not approved for AI use and using AI in the workplace, there can be discipline for that, up to including termination potentially, depending on the egregiousness of the conduct. There can also be a requirement to report these types of violations if we see them, and a prohibition on any kind of retaliation like we see in many other types of policying in the employment space. We have to, of course, reserve our right in this ever-changing environment and landscape to change our policy, just like we should be doing with any handbook and any policy, and reserve the right in this space specifically to contact law enforcement if we ever feel that's required based on our employees' use of technology. None of these things should be foreign ideas to us as employers or to the HR realm. We are allowed to enforce the policies we create in our workplace as conditions of employment. The important takeaway is we need a policy, right? And so that policy can morph over time, and we encourage that it does. But in a world where we are burying our head in the sand or have an absence of policy, we enable our employees to potentially misuse this new technology in a way that can create vicarious liability and exposure for us as an entity or an employer. And as I noted, the idea here is that if and when we need to engage in discipline for misconduct, we can, and we can also protect ourselves as the entity or employer in ensuring that we did have a policy in place that we intended to enforce and monitor. We can't always ensure that our employees won't behave badly, but if we have a policy in place that they violate, we can say they were not acting in their employment function, at least as an initial defense to potential concerns. We want to be really careful in how we monitor this as a flag. AI systems like saying that they have provided everything. As an example, in Texas, a professor fed all of their students' essays into ChatGPT, who every time said, yes, I wrote this to every essay. And so, got into some trouble with the idea of trying to discipline his students for using ChatGPT instead of writing their own essays, when in reality, many of them could prove through Google Docs that they had typed the whole thing over time. So we want to flag that for the reasons we don't 100% trust ChatGPT and other GAI systems right now. We can't trust them for enforcement either, and need to be cautious and careful in that way. Again, as always, handbooks, policies, training are key to protect ourselves and be a first line of defense in potential exposure later. I went through that piece really quickly, or at least tried to, but hopefully the slides can provide you what I missed in rushing through them. I appreciate your time. I know Carolyn does as well, of course, and we're certainly here to answer any questions and spend some additional time or as much time as needed. But thank you for running late with us and for your time today.
All right. It sounds like if you have any questions, this is a good time to ask them. Sounds like I'll kick one off a little bit. Sounds like from what I'm hearing, it's like when we think about going in and helping a corporate entity that we're trying to turn around, in addition to worrying about cash flow, material flow, work processes, now we also have to be aware of information flow. And we want to make sure that we understand what information is being used by this corporation that we're trying to help. We want to make sure that we figure out where AI is being used currently and try to make sure it's being used properly, put in policies and procedures, as you guys have discussed, where it's needed, to make sure that we're not doing something that can hurt us, and possibly consider it to help things along, to help turn around the company. But this is going to basically mean one more background process that we're going to have to make sure we're monitoring. We can't just assume this is all taking place correctly and focusing just on, well, how do I get the cash flow turned around so I can get this business out of trouble? Because while we're working on that, we could have other issues that are undermining us that we're not even aware of. Is that a fair takeaway?
Absolutely.
Yeah, I think it is. I mean, it's sort of we hate to be the bearers of bad tidings and here's more things for you to be thinking about, but it's really much better to hit this on the front end and make sure you have it on your radar, even if it's not, your primary focus, to think about this as you're moving forward in any business context, but certainly in this one too.
Looks like you have a question.
Yeah, the AI developers say they can't tell you how GAI chatbots come up with their answers. How does this lack of transability play into any of this? So it certainly does, Michael. Importantly, in maybe the IP space, there is a huge defense to this idea. So judges that are starting to explore the class action claims by artists and things like that are, how can you identify that this is your artwork if it is a mashup of 10,000 pieces of artwork, right? And so in that way, it is a defense for us, the end user potentially, and also for the software systems in their use of potential protected works. So for now, it is looking certainly like a way of protecting and potentially, of course, abusing people's rights and rights to certain information or certain proprietary rights. But I think for now, it is at least saving us or potentially providing us a defense, which is usually, I'm looking at this from the exposure piece. So for me as the end user of potential proprietary information, I am right now fairly safe, but the law is so unknown that the risk here is what we're identifying.
Anyone else? All right. Well, thank you guys for sharing this information. The danger is it's always more complicated than I want it to be. I want the answers to be simple and served on a platter, but welcome to life.
Right.
Thank you again for sharing what you guys know, and I'm sure that if anybody has any questions, reach out. We can get them funneled to our panelists through Amanda at Turnaround Detroit. At Detroit at turnaround.org. Easy for me to say. Thanks all.
Thanks for having us.